Good morning, everyone. We hope you all are keeping well in these unprecedented times. On behalf of the entire editorial board of RGNUL Financial and Mercantile Law Review, I take this opportunity today to welcome one and all to the RFMLR IBBI conference on evolving dynamics of the insolvency regime in India, 2022. My name is Ridhima Bhardwaj, and I'm a senior editor at RFMLR and also a fourth-year student at RGNUL Punjab. I'll be the host for today's event. I will now briefly tell you about RFMLR and the conference before turning it over to Mr. Harshit Khare, who will be our moderator for the event. Before proceeding, I would like to introduce Mr. Harshit. He is the founder partner of Harshit Khare Law Offices, having over 9 years of experience advising clients in the sphere of insolvency resolution process in various capacities such as counsel to resolution professionals, representative of financial creditors and operational creditors, and also advisor to resolution applicants and investors. Thank you for joining us today, sir. RFMLR is a biannual, double-blind, peer-reviewed law journal published by RGNUL. The journal is indexed on SEC Online and has been consistently ranked amongst the 10 most accessed law journals by SEC Online. The editorial board has also previously collaborated with legal experts and undertaken various academic initiatives and promotes study and research in the field of business and commercial laws. And one such event is the RFMLR IBBI conference on evolving dynamics of the insolvency regime in India 2022, which aims to discuss emerging issues pertaining to not only the wider ambit of insolvency, but also to initiate discourse on the Insolvency and Bankruptcy Code of India. The conference is being organized by the editorial board of RFMLR in collaboration with the Insolvency and Bankruptcy Board of India, which is a key pillar of the ecosystem responsible for the implementation of the Insolvency and Bankruptcy Code. I would now like to take this opportunity to introduce our distinguished panelists for today. We have Mr. Ritesh Kavadia. Mr. Ritesh is an executive director in the Insolvency and Bankruptcy Board of India since 1st February 2018. Sir has 20 years of experience with him in the areas of telecommunication, management, public policy. Before joining the IBBI, Sir has also served in the Ministry of Defense in the Government of India as a director. Next, we have Mr. Nilang Desai. Sir is a senior partner at AZBN Partners. He specializes in restructuring and insolvency, as well as structured finance matters. His practice areas focus on a comprehensive range of domestic and international business reorganization and restructuring matters. With extensive cross-border experience, Sir and his team at AZB have also led highly complex structuring deals in collaboration with international teams. Next, we have Mr. Saurav Panda. Sir is a partner at Shardur Amarchand Mangaldas & Co. with specialization in insolvency and bankruptcy, debt restructuring, structured finance, corporate lending, etc. He has extensive experience in representing banks and financial institutions, strategic financial investors in insolvency resolution processes, and resolution professionals. And Sir has also been a part of several marquee insolvency and restructuring matters. Next, we have Mr. Drupad Vagani. Sir is an associate partner in the banking and financing team and IBC team of ELP, Economic Laws Practice. He has over a decade of experience and has handled and worked on several banking and finance transactions. Sir has deep experience in resolution of stressed and non-performing assets under various schemes of RBI, including structuring, conducting legal due diligence, and drafting of definitive documents. Next, we also have Mr. Pulkit Gupta. Sir is a partner in EY, Turnaround and Restructuring Strategy, and is also an insolvency professional registered with the Insolvency and Bankruptcy Board of India. Sir has also achieved his chartered accountant from the Institute of Chartered Accountants in India and has a certificate of proficiency in corporate insolvency from Insolvency Professional Association, UK. We thank you all to join us today and for gracing us with your presence, and we would be looking forward to learning from your expertise in the field of insolvency. In pursuance of the RFMLR IBBI conference, the editorial board previously invited submissions of manuscripts from students all around the world, all around the country, from various law universities. And after thorough review and evaluation, we have now selected the top entries, which will be published on the RFMLR blog. The authors of the top entry will be awarded with a cash prize of rupees 10,000 and a certificate of appreciation. Further, the authors of the second entry will be awarded with rupees 5,000 and a certificate of appreciation, as well as the third entry will be awarded a certificate of appreciation. I would now like to invite Mr. Sudhakar Shukla, sir, to give the inaugural address of the conference. Sir took charge as whole-time member of the IBBI on 14 November 2019. Mr. Shukla has served as a member of the Indian Economic Service for over 34 years in various capacities across ministries and departments of the Government of India. His last assignment was as Chief Economic Advisor in the Ministry of Rural Development. Sir has also worked in the Ministry of Finance, dealing with matters pertaining to the WTO, African Development Bank, and infrastructure projects of the World Bank. Thank you for gracing us with your presence today, sir. Over to you.
Thank you very much, Ridhima, and I am grateful to RFMLR that such a timely conference has been organized. Basically, when you are talking about evolving dynamics, so perhaps we are also chartering the frontier areas which hitherto have been not substantially touched or untouched. Some spheres which would be under attention of the government and the regulator from this budget session onwards. So it's a hectic time in terms of insolvency regime and changes which we are trying to see. And if you see that IBC is touted as living law, and any economic law in the world is said to be ever evolving. So dynamics becomes very important. If you see the 6 amendments in the code and also the 80 amendments regulations, they have been actually designed to plug the gaps and see that law is emerging and reflecting the emerging economic realities of the day. So we plugged 29A, clean slate principle was arrived and stamped by the Supreme Court. We have we included financial home buyers as financial creditors, and this also was stamped by the Supreme Court. Withdrawal under Section 12A was introduced, and also the massive decisions regarding COVID response were taken through 5th and 6th Amendment. So, and also PPIRP is also in a way can be said to be in response to the crisis situation thrown by the COVID pandemic. So this is how we see that law is evolving in the country, and why this is necessary to have a law to deal with the distressed asset, and why it should be given so much importance across the jurisdiction. Basic reasons are two. Basically, I thought capital resources firstly are finite. So always you are looking for capital resources to be redeployed for better usage, and in the places or in the ventures where opportunity cost is optimum and you can have better results in terms of outcomes through redeployment. So redeployment is basically triggered by the finite nature of the capital, which has to be harnessed over a period of time through saving behavior and other investment drives. So, and second important thing is why we look at robust regimes across the jurisdictions is basically that relates to your basically the spirit of risk taking. So if you don't have such a robust regime, risk taking becomes a casualty. So that is not a very good sign for any economy if risk takers go silent and don't try to take risk and foster competition and innovation to drive the ethos of the economy. So risk taking is an important element, and this has to be preserved at any cost. So that is, and we have seen that. We always say when we are talking about these unicorn companies, we are celebrating 50 unicorns in no time. These were developed in the country. But if you see the other side of the story, that over 90% of fresh your startups are being wound up and not being successful, then you have to see that basically you are caring for unicorns is good sign, but you have to see that you have to preserve the risk taking ability of the entrepreneurs which are stranded in the startups which could not take off. So that is why we always talk about the robust nature of IBC and the voluntary liquidation in particular. And this is one area where you will be seeing some reforms coming in and trying to plug the gaps which are existing in the code and the regulations. And perhaps surely timelines are currently not defined. Endeavor to do it 1 year is not good enough. We have to see that not only we provide withdrawal mechanism which is befitting to the code objectives, and also serves the aspirations of the evolving market. So definitely you expect something on voluntary liquidation timelines and how it would be rolled out. Its withdrawal is not provided in a sense that anything which has not reached the AA's jurisdiction, but if you are withdrawing it, you have to go to get the stamp of AA. So I thought, and we in the as a regulatory body have always in the thinking process that basically the process which has been initiated by certain like requirements, it should also be provided to be withdrawn by using requirements at the stage to which a particular company has reached, instead of saying everything has to go to AA. So these things are on anvil and they would be coming. So we are saying the spirit of the investment ethos, basically we are trying to discharge both capital and the risk takers, this which is very important in dealing with the situation in any economy. So this is important part to keep in mind. And if you see the IBC processes, today we are proud of many of the results, but it was not without hurdles, and hurdles are basically are continuing to be unfolding as the IBC juggernaut moves forward. So basically, what we see is at the time of 5 years back when we announced the IBC, ecosystem actually was non-existent. Basically, we were not sure who would be dealing with the IBC cases as a IP, and this actually the institution of IP and IPA has actually served the court so much better that even at the drawing stage when we were struggling how the ecosystem would be evolving, that part actually has been negated by the robust nature of demonstrable results achieved through this IP and IPA mechanism, which was evolved over a period of time. So, and the second issue was basically capacity of NCLT. It has been at times said to be a major constraint, but government has already announced more cities to be covered through NCLT, more seats are being created. So intention of government is very clear that this NCLT capacity should not hinder the process of IBC to be completed in a time-bound manner. In IBBI Singapore case also, we have seen that they have pronounced that nobody or no institution, no individual will be allowed to undermine the time-bound nature of resolution, which is enshrined in the IBC code. So that is important. Supreme Court has taken cognizance of it. How they will do it, time will tell, but definitely it has given a strong message that any procedural delay or delay at the litigation stage is unacceptable. So both way, we have to be vigilant to what we do with the ongoing regime. Basically, I wanted to touch some of the areas which you are discussing today, because I thought in the inaugural address, I should be dealing with the perspective on what you are going to discuss today on this important topic, overarching topic of dynamics of IBC. The first topic I thought is personal guarantors. Personal guarantors, we were initially criticized that we partially rolled out the individual insolvency regime by changing a definition, but it was thought prudent that individual insolvency, part of it has to be implemented as corporate insolvency is already in vogue, and without roping in the individual insolvency, story would not be complete. And that is why the definitional aspect of this guarantors under the individual insolvency was changed and implemented at first stance, because otherwise individual insolvency regime is yet to be notified, and it is still some time and still some gaps we plugged with before we can go into individual insolvency regime. So that is why this was necessary, and Supreme Court decision would be certainly we discussed today. So it actually cleared the way that what amendment we did was right, and these personal guarantors have to be made accountable for mistakes they have done in siding with the promoters, in getting the size of debt which was otherwise banking system was not able to extend to them without these guarantees. So this is important aspect, and more important is basically 2-3 days back, I think it is Thursday, when NCLAT has come out with the decision that personal guarantors actually it is not necessary that for invoking personal guarantee you have to have a CRP case registered under the code to sue these guarantors. So they have made it clear that even if CRP case is not on, these guarantors can be, a case against the guarantor can be filed and pursued within the ambit of IBC under the relevant sections. So this is a new clarification. Only 2-3 days back it has come. So maybe this would be part of the discussion today. Second discussion topic is areas of improvement in the IBC vis-a-vis stressed asset resolution. This is very important area, because we thought when we are always responding to delays and trying to plug the areas where laxity are very visible. So these area of improvement are tremendous in moving forward to roll out the IBC in its complete sense and objectives. So basically, what we are thinking and with what discussion paper has already been floated by MCA for taking up in the budget this year, there are some definite directions given regarding improvements which we need in the IBC with regard to basically plugging the processes at the admission stage is very important. We have seen that delay in admission is important not only from the visibility point of view, but also if you see the economic sense when this delay happens during this twilight zone, lot of avoidance transactions are said to happen, and that is why it is necessary that once it is case has been filed, there should be no delay in admission, and if there is a delay in admission, so your area to look back under the avoidance transaction has to be from the date of filing and not the admission. So while government is trying to plug the area of admission by making it like mandatory for IU default record to be mandatorily adopted under Section 7 application. So that would enable the AA to admit the application without delay. And the second consequent reform would be that avoidance transaction has to be from the date of filing and not the date of admitting. So that two things we are basically trying to plug, and also the discussion paper is trying to highlight that many times after the wisdom of COC, economic wisdom of COC has been made available, a definitive plan has been voted, still there are several cases which are languishing over a year's time in want of decision. So this again is a serious concern, and because we thought that when we are talking about value preservation, if you take a lot of time, you are actually killing the value over a period of time. So this, to prevent this value deterioration, it is imperative that decisions are taken in time and communicated to the parties, of be it promoter, be it resolution applicant. So all need a quick disposal. And for this, actually, discussion paper is saying that now court would be providing 30 days dispensation to AA so that they have the tick-based approach, they tick mark all the information they want to have, and after that they just pronounce the judgment without going into detailed litigation thereafter and waiting for more clarification being coming from various litigants. So we thought that this making 30 days is possible, and perhaps if discussion paper gets final nod from the stakeholders, then it would be moved to the legislative state for clearance in the parliament, maybe during the budget session. So this is how areas of improvements look right now in the paper which has been floated already. Then the third topic is on cross-border. Cross-border again has been, the paper has been out, what is the wish list, and we have already received comments. Major change from the ILC report and the KP Krishnan report has been that we have said that basically personal guarantors can be not left outside the scope of cross-border regime, and this has been provided for in the revised formulation, which discussion paper highlights. So this is very much a topic of the day. very much options are to see that this budget session, this fructifies as a one major reform which everybody is looking forward. Then you have alternate resolution insolvency dispute for the resolution process, and all over world, basically, we have seen in all the jurisdiction, there is a thinking, there is a churning after the COVID that there should be some dispensation so that resolution can happen without uh, any interference of the law, maybe mutual consent and mediation. So that is still in Indian context is in discussion process, and sometimes, which is the last topic of the day, in context of pre-packaged insolvency, basically there's what we have provided. People are saying that this is like this outside the aid discussion between debtor and creditor. This regime needs to be implemented in the context of big corporates as well. So this is the demand of the market, which they say that this would be necessary in moving forward, but surely the debtor in possession and creditor in control model, which has been prescribed under PPIRP, it is very difficult to make it universal because we have come now in a stage where we always say that your basic principles of the code have been well defined and endorsed by the jurisprudence. So disturbing that would be a difficult proposition. So we have to see that in times to come whether we can move to a universalization of PPIRP or not. But currently, as the code stands and the jurisprudence, there are, I think, reservations from the part of regulators also that how can you, the regime which was overthrown by IBC was based on similar principle of lifelong negotiation between debtor and creditor in private without involvement of AA, and that has created a lot of NPA. And this is why when you are coming to new regime, new results, we have to see that creditor and control, creditor in control should not lose focus. So this is, I thought I would be sharing as a inaugural part. And with these words, I wish this conference and the panel discussion all the best. Thank you very much for having me here today.
Thank you so much, sir, for your enlightening words. We definitely have a lot to learn from your expertise. Thank you, sir. So we will now be proceeding to the next segment of the panel of the conference today. We will now be announcing the top 3 entries of the RFMLR IBBI block series competition that we have already released and we have informed the authors. The first position has been secured by Priankita Das, a 4th-year law student at Dr. Ramanohar Lohia National Law University. The second position has been secured by Tanvi Apte, a 5th-year law student at Nalsar University, Hyderabad. And the third position has been secured by Trisha Singh Naulakha and Ishu Gupta, 5th-year students at Symbiosis Law School, Noida. I congratulate all the authors for their victories and also the other authors who put in commendable efforts in sending manuscripts which discussed such niche issues in the area of insolvency. I will now invite Priankita Das to present her research before the panel and the attendees briefly before we begin with the panel discussion.
Just want to confirm, am I audible and visible?
Yes, you are.
All right, great. And is the PPT visible as well?
Yes.
If anyone could confirm.
Yes, it's visible.
All right, great. Thank you so much. So, good morning, everyone. My name is Priankita Das, and I'm currently a 4th-year law student at Dr. Ramanohar Lohia National Law University. I have been given the greatest opportunity by the RFMLR editorial board to present my research today at this conference before such an esteemed panel of experts as well as attendees. The article that I had submitted as part of the RFMLR IBBI blog series competition is titled Initiation of CIRP of Personal Guarantors in Absence of CIRP of Corporate Debtors. Where does the law stand? The objective behind writing this article was to analyze whether the CIRP of personal guarantors could be initiated if there wasn't any ongoing CIRP of the corporate debtor. Now, to give a very brief overview of the paper, I have firstly gone on to analyze the statutory setup by relying upon the provisions of the Indian Contract Act 1872 and the Insolvency and Bankruptcy Code 2016. Thereafter, I have specifically chosen to analyze the conundrum presented by Section 60, Clause 2 of the IBC, which has been differently interpreted by the NCLTs and the NCL. Thirdly, I have guarantors in the absence of a pending CIRP of the corporate debtor. And finally, I have proposed 3 solutions to simplify the entire process. To begin with the statutory setup, it is the Indian Contract Act 1872 that governs the relationship between corporate debtors and their personal guarantors. Section 128 of the Act states that the liability of the surety, that is the personal guarantor, and that of the principal borrower, which is the corporate debtor, is coextensive and both are jointly and severally liable for the repayment of the debt. This means that both the entities have the same obligation of repaying the debt, no more and no less. This position has also been reiterated by the RBI, which is the Reserve Bank of India, in its Master Circular on Windfall Defaults. Now, from statutory point of view, this should have sufficed to answer the question in an affirmative manner that yes, creditors can proceed against both or either the personal guarantor and the corporate debtor. However, the provisions of the Insolvency and Bankruptcy Code of 2016 also have to be looked at because as per Section 238 of the IBC, any law that is contrary to its provisions shall be superseded by it. Therefore, the IBC becomes the supreme law that governs personal guarantors and corporate debtors. Now, I have placed reliance on one particular section of the IBC, that is Section 60, which deals with the jurisdiction of the NCLT over personal guarantors. As previously mentioned, this particular section has been interpreted differently by the NCLTs and the NCLAT. Now, Section 60 subclause 2 of the Insolvency and Bankruptcy Code reads as, where a CIRP of a corporate debtor is pending before a NCLT, an application relating to the insolvency resolution of a personal guarantor of such corporate debtor shall be filed before such NCLT. Now, the Mumbai bench in 2021 in 2 cases, Capital Private Limited versus Ketan Vinod Kumar Shah and Alteco Capital India Limited versus Rajesh Patel, opined that Section 60 subclause 2 makes it mandatory for there to be a pending CIRP against the corporate debtor to initiate the CIRP of its personal guarantor, thus answering my research question in the negative. The NCLT Mumbai bench laid emphasis on the usage of phrase CIRP pending before a NCLT and came to this conclusion. However, as also discussed in the inaugural address today, very recently, just 3 days ago on 27th of January 2022, the NCLAT delivered its order in State Bank of India Stressed Asset Management Branch versus Mahendra Kumar Jajodia and held that the purpose of Section 60 subclause 2 is that when proceedings are pending in a NCLT, any proceedings against the guarantor should also be filed before such NCLT. It laid emphasis on the terms a NCLT and such NCLT and guarantor are happening before the same NCLT for the ease of the creditors as well as the adjudicating authority. Section 60 subclause 2 does not in any way prohibit the initiation of the personal guarantor CIRP in the absence of a pending CIRP of the corporate debtor, and thus answers my research question in the affirmative. Now, given that the order has come from a higher authority, that is the appellate tribunal, and also is more recent in time, it can be said that at this point of time, this is the presiding rule of law. And CIRP can be initiated of personal guarantors in the absence of an ongoing CIRP of the corporate debtors. Now, I have gone on to analyze what could be the possible consequences of both barring allowing such initiation. Now, if the initiation were to be barred or prohibited, it would lead to the diminishment of the coextensive liability of the personal guarantor and the corporate debtor. Would not be able or utilizing their remedy against the corporate debtor independently, thus somewhat defeating the purpose of Section 128 of the Indian Contract Act. Now, if the initiation were and 101 of the IBC. These provisions are applicable to personal guarantors and provide a very expansive restriction on creditors from initiating any legal proceeding with respect to any debt. This thereby means that the creditors are not allowed to proceed against the corporate debtor once the moratorium is in effect, and they would lose their right to simultaneously proceed against the corporate debtor and its personal guarantor, as has been granted to them recently through several case laws. Now, given such consequences, I have proposed 3 solutions to simplify the entire process. First is to make an exception for proceedings against the corporate debtor from the moratorium by inserting an exception under sections 96 and 101 of the Insolvency and Bankruptcy. This would ensure that creditors retain their right to proceed against both entities independently and or simultaneously, thereby preserving the coextensive liability as well. Second suggestion is to insert a proviso under section 60 subclause 2 to settle the different interpretations given by the NCLTs and the NCLAT and have a clarity as to what the legislature had intended to be the purpose of section 60. Lastly and finally, it has been suggested that during simultaneous proceedings, the CIRP of the personal guarantor can be concluded first to enable it to admit its claim as a creditor in the CIRP of the corporate debtor, and thus exercise its right of subrogation in light of the principles of Indian contract law. With this, I believe I have come to an end of my presentation. I thank the RFMLR editorial board and its members, the esteemed panel of experts, and the attendees for allowing me to present my research today at this conference. Thank you so much.
Thank you, Priankita, for touching upon this topic of individual insolvency resolution process. And it is now that we begin with the discussion with our esteemed panelists on such niche areas of insolvency and the evolving dynamics of the regime in India. Before starting, I would like to request all the attendees to direct any questions only to the panelists designated as Q&A. I refrain from directly sending any questions to the esteemed panelists or the moderator. Harshit sir, the floor is now all yours.
Thank you so much, Adima, and thank you so much, RGNUL and IBBI, for giving me this opportunity to moderate the session. I hope I'm audible and I'm visible.
Yes, sir.
Thank you so much. I think as far as the laying down of agenda is concerned, Mr. Sudhakesh Shukla has already very beautifully laid down the agenda and briefly touched upon all the 5 subtopics which we are going to discuss, be it personal guarantors, PP, IRP, cross-border insolvency, ADR methods, and the stress asset resolution vis-a-vis IBC. So without wasting any much time, I think we'll quickly begin with the first subtopic, which is evolving position of the personal guarantors. And I'll probably direct my questions to specific panelists, but if any other panelist has any view, please feel free to jump in and put on your views, and do let me know if I can help in that. So the first question would be that in terms of the process defined under the IBC, what is the difference between a CIRP process of a corporate debtor and the insolvency resolution process of a personal guarantor? I'll be happy if probably Saurabh can answer this question, or any other lawyer on the panel would be happy to answer this question.
Thanks, Harshit. See, in case of a corporate debtor, the entire process is structurally very different as compared to a personal guarantor's insolvency. Right from the stage of initiation, the process is very different, because in case of a personal guarantor, the initiation could be made directly by the debtor, which is of course also allowed in a CIRP, as well as by a creditor. Both of these things are common. However, in case of a personal guarantor's insolvency, the resolution professional plays a role right from the stage of initiation itself, wherein it is the resolution professional who can also file this application for the insolvency of the personal guarantor. Apart from that, as you know, in terms of the moratorium which is granted under a corporate insolvency resolution process, that only kicks in once the case is admitted, once a insolvency process is admitted. Whereas in case of a personal guarantee, personal guarantor, it is really split up into two parts. There is initially an interim moratorium, just to ensure that there is protection of the personal guarantor against any other proceedings initiated for any debt. I think the person who was displaying that research, she was also indicating about it. And of course, once there is admission, there is a more detailed sort of moratorium order which applies to pretty much every proceeding against the personal guarantor. Most importantly, the whole objective of a corporate insolvency resolution process is to arrive at a resolution plan per se, right? Which could typically have any third party also have an equal opportunity to provide a resolution for the corporate debtor and really, take over the entity's control, and of course, pay out the creditors per se. But the principal key difference here is, the personal guarantee. In case of a personal guarantor, you are really looking at a repayment plan. So there is a provision for a repayment plan to be provided by the personal guarantor, which is then verified by the resolution professional. And then you take it to the adjudicating authority for approval. So it's really more of a case of a discharge of the existing debts as opposed to resolution of the corporate debtor through buyouts and acquisition of the company for obvious reasons. Now, of course, the whole personal insolvency sphere is very wide, because what we are really talking about here is just the part of the insolvency resolution process, right? There's also a possibility that the repayment plan really is not a feasible option in a particular case. Now, in such cases, typically it will go towards the bankruptcy, or there are similarities of a bankruptcy with a liquidation process per se of a corporate debtor, for example, wherein you are really looking at the estate of the personal guarantor, and you will then sort of split it amongst the creditors because the estate perhaps is not adequate enough. In terms of the role of RP, also the role is very different in both cases, because the RP has a limited role in a corporate insolvency process from the perspective of the studying of the repayment plan, etc., or the resolution plan per se, because he's really looking at compliance with the mandatory provisions of the code, etc., under 30. But in case of a repayment plan, his role is much wider. He's really reviewing the entire repayment plan and then trying to get concurrence from the committee of the creditors. So there are similarities, but there are distinct differences in both these processes per se. Arshit.
Thank you so much, Saurabh. I think you briefly touched upon the role of resolution professional vis-a-vis the processes of CIRP for corporate debtor and of that of a personal guarantor. I think it would be great if we can have views of Pulkit Gupta also here, because he, being the insolvency professional, can probably give us more insight about how the role is different in both the scenarios.
I guess in the case of personal guarantor, there is a lot more to be done by the RP individually. In case of a CIRP, he does get a lot of support from an team which he can appoint if required, professional he can appoint, and also from the COC. In case of personal guarantor, there is a lot more which, as an individual IRP or insolvency professional, which you need to do. And also right now, like if you even see the latest case, latest newsletter from IBBI, there are about 500 applications filed, about 60,000 crores of claim already filed through personal guarantor application. But in terms of success or closure, it is very limited. So this is an area where as an insolvency professional, you work through it in 2016-17 for CIRP cases, where you sort of learning on ground. Next couple of years would be interesting for the insolvency professional to learn this on ground, figure out what are the best options available to you, and then accordingly this will mature. And one biggest challenge which I will highlight in this is the asset tracing. There is no corporate debtor where you need to go out and take control. There is no going concern to be maintained. The personal guarantor will give you a list of assets, but obviously you know that he would not be disclosing everything which he potentially would have. So you'll have to work out various permutation combination to identify what could be the other assets which could be brought into the ambit of this application, and then sort of sold off, and the money could be distributed to the creditors. So that would continue to be a challenge. And after the introduction of this, the promoters or the guarantors are also becoming intelligent, and they are structuring it in a way that you cannot reach those assets quite easily. So that will be one challenge. More jurisprudence will develop around this, and next couple of years would be interesting to see in terms of how the ecosystem develop around the personal guarantee enforcement.
Yeah, thank you, Pulkit. I mean, you briefly touched upon the practical aspect, how things are going to be very difficult in terms of the process for personal guarantors. On that practical aspect, I think I have a question for Mr. Ritesh Kavadia. That obviously, I mean, earlier it used to be a paper security, just a guarantee by a personal guarantor, because we did not have enough remedies available against them. Now, because we have these provisions where we can initiate the insolvency process against the personal guarantors, do you think the nature has changed, and even the mindset of the promoter would change now, Mr. Kavadia?
Yes, basically this code has been a game changer, and it has changed the equation and balance between creditors and debtors. And it was in fact one of the reasons that this personal guarantor were brought into the ambit of IBC, because the corporate guarantors, the companies giving guarantee to another group company, they were under the ambit of IBC, but the personal guarantors were not under the ambit of IBC. So to bring them onto the same level, or to remove this arbitrage, this at least this part of individual insolvency was rolled out. So creditors have gotten another remedy, effective remedy to pursue their claims. The IBC is not an exclusive, you can say, platform. They can pursue their remedies even outside IBC. The actual provincial laws have not been repealed for them. They can even pursue under SURFACE or any other platform that they have, but IBC has given an additional option. Right now, it has not yielded much results, final results as of now, but of course, with the experience of CIRP, it has put these promoters into a difficult situation, or they have got some fear of IBC, and multiple cases right up to the Supreme Court by various promoters gives a testimony that the creditors have got another tool or another arrow in their quill.
Correct. Mr. Desai, if I can have your views on this, that whether the IBC and the provisions relating to insolvency of personal guarantor have changed the mindset, and it's actually going to add another wing, another remedy for the creditors.
No, I think it has. Just as when CRP came in for companies, there was a tectonic shift really in the mindset of promoters. I think as some banks told us pre-IBC, they had to go to the promoters' offices, and post-IBC, the promoters came to their offices saying, "Let's please settle," etc. So there was certainly a shift at the promoter end for their companies. And I think with the personal guarantor process kicking into effect and proceeding slowly but surely, I hope, I think a similar impact is going to be felt on promoters, where they will want to settle even earlier, whether this personal guarantor process is, I think as Pulkit mentioned the stats, lots and lots of applications. But the problem is, while I think the fear has set in because the applications are being made, I think until a whole bunch of promoters find the assets being taken away, that fear won't spread.
That's
right?
correct.
Who had the assets away, have a ripple effect throughout the country, frankly, because it makes the front pages, etc. It's embarrassing, so on and so forth. So really, that ripple effect hasn't kicked in yet. And I almost wonder why that is. Why is it that financial institutions are slow to file personal guarantor claims, slow to follow up on them, slow to push them through? What is it that's stopping the process right now? And I wonder whether during the CRP or the corporate debtor, the NCLT should be looking at this as a holistic process, right? Because effectively, this is recovery for the creditors, right? Whether it comes from the company or the person guarantee. And whether the NCLT at the corporate debtor stage should be asking the question of those COC members who have the benefit of a person guarantee. Have you filed? If not, why haven't you filed? If you file late, why have you filed late? Why have you not pushed it on? Why are you asking or permitting delays or adjournments, etc.? Maybe a little bit of proactiveness from the NCLT, and merely when I say proactiveness, merely asking the question of the COC members may sort of get some of these members of the COC to be a little more reasonable and sensible about proceeding with these personal guarantor claims. Because what I find is, in one or two cases they'll have pushed. In 9 or 10 cases they won't have, and there is no understanding of why they're taking a view in some but not others.
That's correct. In fact, when the couple of banks, the creditors, they initiated the process against the personal guarantors or initially the corporate guarantors, there was this whole issue of double dipping of claims, that you have already initiated the process against the corporate debtor, you have recovered your money, and the debt is already settled. Now, in terms of law, how you can come and file another process, another legal process against me. In fact, I'll be happy to have a view of Tripal Bhagani if you can probably talk about this aspect on double dipping of claims and what is the current judicial standpoint.
No, so double dipping of a claim, somehow, see, you have to understand the perspective that though there are parallel process going on, one against the personal guarantors and against the corporate debtors. At the end of the day, you would always see the liability from a practical standpoint of view. The liability will be more than the asset. So at the end of the day, none of the creditors are going to recover the entire amount. But even if that is the case, if you look at it from the perspective, at the end of the day, no creditors under any scenario can get more than what they will get. So eventually, if they're getting it from either the personal guarantor or from the corporate debtor, they can't recover more than the debt amount that they would have. So I frankly would have not seen come across any double dipping of case. But and practical situation is that the liability will always be more than your asset.
That's correct. That's correct. So moving on to the next question, I think.
Harshit, I
Yes.
would like to add one more point here.
Please,
that
please.
Even in CRP, when the creditor files a claim, it has to submit that if it receives some amount from any other source, it will have to update its claim. That undertaking is very much there. So some due diligence and some checks and balances are already there that to ensure that this no one can have more than what it has given. And in any case, if the fact that both the proceedings happen under the same forum does help the cause that as such no one can abuse the process. Sorry for interrupting.
No. Thank you so much. Thank you so much for your views, Mr. Kavadi. In fact, I think from the judicial standpoint, also to the best of my knowledge, it is pretty much settled that obviously your remedy does not go away against the guarantors, even though a part of your debt has been settled vis-a-vis the corporate debtor, which is the borrower. So certainly, thank you so much for your views. In fact, I was moving to the next question, which is the jurisdiction of DRT and NCLT. I think Priankita, who was one of the finalists, earlier talked about the jurisdiction and whether NCLT and DRT. So how do we decide if I'm a creditor and I have to file a petition to initiate the process against a personal guarantor, whether it would be DRT or NCLT? If I can have views of Saurabh Panda, please.
See, Arshit, with the recent NCLAT judgment, I think NCLAT has further clarified the position unambiguously. Of course, it remains to be seen how eventually Supreme Court looks at this issue. But see, if you look at section 60 subsection 1 and you read that together with 60 subsection 2, I think the position is fairly clear that if you are really looking at a personal guarantor of a corporate debtor, the appropriate forum for that is the NCLT and not the DRT. Of course, the section 95 and the chapter on insolvency of individuals, that of course certainly applies, but it has to be read harmoniously with section 60. And therefore, in my view, the position taken by NCLAT appears a tenable position, that indeed, irrespective, and there have been multiple cases where we have also been asked for views that what do we do in cases where the insolvency has already ended, right, as in for the corporate debtor. Does that become a bar for us to approach the NCLT at this stage, given the fact that technically there is no pending proceeding? But I think that position has rightly been decided by NCLAT that indeed NCLT is the appropriate forum. That also, by the way, will help resolve the issue that you raised about double dipping, etc. Because the NCLT, having been seized of the debts and claims and how that is being resolved insofar as the corporate debtor is concerned, we'll have a holistic view about the overall resolution, right? And that is very, very critical in case of a personal guarantee, personal guarantor's insolvency, because really what the entire obligation that you are trying to resolve is emanating from the debt originally taken by the corporate debtor, correct? So I mean, certainly, in going forward, I expect that it will all flow down really practically in the NCLT, and I completely concur with the suggestion given by Nilang as well, that really banks should look at going for a holistic resolution by going against both the corporate debtor as well as the personal guarantors, given the coextensive nature of the liabilities.
Correct. So would it be correct to say that in the event the proceeding against the corporate debtor is going on already before NCLT, then obviously NCLT is the appropriate forum to go against the personal guarantor?
Even if it has ended,
okay,
it necessarily needs to go to the NCLT. If you talk about a situation prior to any insolvency being initiated against corporate debtor, frankly, it's a little theoretical, because the entire obligation of the personal guarantor will only kick in once you have you've crystallized the debt insofar as the borrower is concerned, right? Because you will obviously call upon the borrower and the guarantor to pay. So, and the asset base usually always lies, we've seen with the corporate debtor, but practically you'll really need to go to NCLT in these personal guarantee cases.
Thank you so much, Saurabh. So when we're talking about the two different forums being there, NCLT and DRT, and obviously we have seen that the robustness of NCLT, there have been very recently there have been appointment in the NCLT also. There have been many benches also. But from the perspective of DRT, do you think that we need to probably, or the government need to really appoint more members in the DRT? In fact, at DRAT level, if you see, there are very less people. There are many DRAT which are vacant, because of which the appeals are not able to be filed or appeals are not being taken up. So, Mr. Kavadia, what is your view on that?
Yeah, of course, the capacity at both the NCLT and DRT, they needs augmentation, and augmentation in a big way. There is absolutely no doubt. Whole the world is saying that government is very much conscious. Government even in the last budget announced that they will be taking up augmentation and capacity of try to build up capacity through other means like e-code system and all. So capacity even for personal guarantor, as Saurabh has correctly told, that practically it has to be NCLT. More than 95% of the cases have been filed with NCLT only as of now. So, but even however it comes, even for the existing cases, DRTs are very much struggling, and that is one of the major consideration while we roll out individual insolvency for the next bunch, that is partnership firms and proprietorship firms. For that, a serious augmentation of capacity at DRT will be required.
Thank you so much. So before we move on to our next subtopic of the day, probably I would be happy to have views of all the panelists one by one as to how we can improve the existing regime of relating to personal guarantors. What improvement would you like to see? I'll start with Mr. Desai.
I think I don't have any new suggestions besides those which were already picked up by other panelists. I think certainly more members at the NCLT and the DRT level. Certainly, I think more coordination between these members. I mean, too often we've seen, judgments say one thing in one court, something else in a different court, and then months and months before there's resolution on a unified process. I think that just has to be avoided. It cannot be the case that one judgment says X and another says Y without considering X in the first place. I can understand if the judge considered the first judgment, distinguishes it, and then goes in a different way. But for two judgments not to be considered, I think that's just it's embarrassing. I think that really has to be stopped. And I suppose that extends not only to the personal guarantor space. I'm talking about judgments in the IBC in general. Certainly, I think if there is better coordination, maybe at the NCLT level, where, as I said earlier, questions are asked of the COC why processes aren't starting simultaneously and proceeding simultaneously. I think that could help in a more time-bound resolution of both the processes, and therefore also in more. I don't want to use the word fear, but to have more responsibility amongst personal guarantors. In A, running their companies, B, when giving out personal guarantees. I think there was a time when the enforcement of personal guarantee was so laborious, so painstaking that it just never happened, and therefore personal guarantees were dished out. I think, promoters will be a lot more circumspect now about giving personal guarantees, and that's right, because really, what is a bank doing over there? If you think about a bank's lending pattern, what it should be doing is it should be lending on behalf of that company. But by joining the personal guarantee, it's really saying, I don't really care whether it's company or you, it's all the same thing to me. But that's not how the credit analysis should be done. So I think, as promoters realize that personal guarantees are going to be enforced, they'll be more circumspect. And as they become more circumspect, banks will have to do better credit analysis of the company itself. Sorry, I digress, but I wanted to make this point. So yeah, sorry, I'll stop there.
Thank you so much. Mr. Pulkit Gupta, would you have any suggestions relating to personal guarantor regime?
Yeah, in my view, asset tracing will continue to be the biggest challenge. Otherwise, if that is not resolved, then on a lighter note, it might be good for a lot of people on the call being lawyers, but ultimate objective may not be achieved. So we'll have to use whatever it takes. Use of technology may be one solution, but we'll have to create platforms where asset tracing can be done quickly. And just one other point which Nilang also touched upon, that I would assume that more and more promoter would be now not open for giving personal guarantee. What does that do for the credit culture? And are banks open to lend without getting personal guarantee? Because it's a practice, irrespective of your credit rating, to get a personal guarantee, which now if I'm a promoter, I would think twice before I give if my project has good rating. So that's another thing which banks will have to sort of start getting used to.
Lawyers will benefit.
Sorry, say that again, Nilang.
And I'm just teasing, Pulkit. It's not only lawyers will benefit, accountants as well.
But not in line with what lawyers will get.
If I can add, lawyers are getting benefited irrespective of the situation. In either side, lawyers will get some of the other benefit.
Yeah.
Nonetheless, moving on to the next segment, which is areas of improvement in the IBC vis-a-vis the stressed asset resolution. So here I would like to talk about one particular aspect, which we, since IBC came into being, we always talk about low recovery rate for the creditors. That as far as the recoveries are concerned, those are not as good as it should be or as it was intended to be. And when I think about low recovery rate, two important aspect comes to my mind. One is the valuation of the corporate data, and the other one is the non-availability of adequate information for due diligence. So from the legal as well as commercial aspect perspective, I would like to have views from everyone. I'll start with Mr. Kavadia. What do you think about these two aspects and how these are impacting the resolution or the recovery?
Yeah, basically, so IBC came into existence recently. You can say 5 years is a short time in terms of law, and this all these issues or NPAs are lingering for a long time. Banks have long uh, uh, removed them from their books, simply written them off. There are many companies we have reported many times, like Gotaringa and Orchid Healthcare, where more than 8,000 crore of claims are there, but the liquidation value is simply zero. They don't have any single piece of asset to back to satisfy those claims. So, if such kind of companies come into our insolvency system, obviously the realization will be low, and we have to see the best in it. Suppose we don't resolve, then what? It goes into liquidation, and unto the liquidation you get what? Liquidation value plus after deducting the liquidation cost, which will be even lesser. So best is that this is a market mechanism. We should focus more on building the market. If 10 resolution applicants are there, information symmetry is there, then this valuation can only be just a guiding factor for stakeholders. Ultimately, you have to give asset. Claims do not justify any or do not bring any resolution applicant. Resolution applicant can only come if asset is there. In the long term, as we progress, this insolvency will be kicked in when this stress is just recent. It's not chronic. Assets or business has not deteriorated to such a level, and probably at that time these promoters will be keen that they somehow satisfy their creditors and retain the control. In some of the large insolvencies, one group company was lost, the promoters somehow managed and paid off in another group companies to avoid similar fate. Some large corporates, I would not take the names, but this has happened. So, going forward, these things will be improved. Right now, if you see the liquidation, 75% of the companies were simply defunct. They would not. They were BIFR cases. So all this valuation and haircut, as such, we can have concerns over them, but ultimately it's the past decisions and past long pending cases. No legislation can create value as such. Whatever value is there, that has to be best and optimally used. That is the purpose of this law.
That's correct. That's correct.
Rashid, if I may just add.
Yes, yes, please.
See, the haircut for the creditors makes very good media articles, but really that is not the right approach to look at the insolvency resolution, because you really have to, as Mr. Kawadi rightly pointed out, you really have to look at what is the asset that is under resolution. You may have taken a very significant credit exposure, but that really does not mean anything, because that is the basis for any resolution applicant to put a resolution. The resolution applicant, I mean, that's the whole basis which drives the IBC, that it is a market-driven mechanism where you provide a platform for potential resolution applicants to put the highest value and take the asset in a legal process. Now, therefore, you really need to look at it from the perspective that this is the asset for which we've been able to find a particular value. Probably, I mean, arguably, one could look at the liquidation value and assess basis that whether what is the resolution value. But to look at the credit exposure or the total amount of admitted claims and comparing it, that may not be the right approach in any case. That is not even commensurate with the whole approach that this is a resolution mechanism and not a recovery mechanism. And sorry, I just had one more point. I just complete that, because you also pointed out about the information asymmetry that exists. Now, see, there are various cases which you rightly pointed out where there is information asymmetry, but the resolution professional is really an outsider to the process, right? And his whole, while of course he has this very wide-ranging responsibility to take over all assets of the company, to take over all books of the company, but really he's dependent on the company's personnel, right? And there are various cases where there are no company personnel also by the time the RP, takes over, correct? Now, in such cases, I think somewhere Section 19 also the ambit of Section 19 also needs to be widened so that the RP can also try further measures going beyond the personnel of the company to try and get information, which could potentially also look at, promoters, etc., any other person. I think there is some proposal to make some amendments to 19 to cater to that. Maybe that will help ease the information asymmetry to some extent.
No, that's correct. In fact, when we're talking about these two aspects, we are actually talking about the entire ecosystem. Unfortunately, as Mr. Ratish Kavadi has said, the issues are of the past. It's not that issues are coming today and IBC can come and resolve everything. The unfortunate part is that even the resolution profession is not able to get the information. But how it impacts the resolution applicant, if I can have views of Mr. Pulkit Gupta on that from the resolution applicant investor perspective, how information asymmetry is a problem.
Before I answer that, my personal views, I feel quite disappointed and sad with all the hype in media about low recovery, high recovery, good recovery, bad recovery. I don't think we can generalize the recovery process in IBC into buckets. I don't know if you can say if a 50% recovery is a good recovery or bad recovery. It has to be dependent upon the case. What is the inherent value of the asset? In some cases, even 10% recovery is a good recovery. In some cases, even 80% recovery is not a good recovery. It's a commercial law. Commercial judgment should be applied by the COC before they approve a plan. And maybe it's 5 year now to IBC. There are about 400 odd cases which are resolved in CIRP. It will be good to see that what is the value of the company which are resolved in IBC now. I at least know 10 cases where it is worth multiple times than at what value it was resolved when the COC approved it. There is one listed company in which COC took a plan for 4,000 crores. It is right now worth 40,000 crores. Had they taken 10% of equity in that company, their recovery would have doubled in 18 months from them. So it has to be a more creative solution by the COC also if they want to sort of improve their recovery. If they just think on a straitjacket approach, just want cash on day one, then it's a stress asset. Day one, obviously, it will not be worth what it could be worth in 12, 24, 36 months after the recovery. And to answer your specific questions on how does it impact resolution applicant, obviously in a M&A process, all information and time is always a challenge. You always want more information, but good thing is that because you can cover a lot of your historical risk by putting that in a resolution plan. So because I've done diligence also, I guess doing diligence in a IBC or a CIRP scenario is much easier because ultimately you just want a broad understanding of what the asset is, and everything else then get covered into your protection which you build into your resolution plan, which goes for NCLT approval. So as such, it's not really a big significant challenge for resolution applicant. Obviously, he would never be happy with the kind of information he'll get. He would want more always if possible.
That's correct, Mr. Pulkit Gupta. Yeah, I had somebody was saying something. Mr. Desai, you were saying something?
No, I wasn't. But just 2-3 quick comments, if I may.
Yeah, please.
Liquidation value, and I think there's been a lot of controversy about whether disclosing liquidation value was depressing pricing. I think maybe in a certain category of cases it might have been, where there is no competition, there's only really one bidder, and the bidder knows that the price is just above liquidation value. The banks will be forced to, or the COC will be forced to accept it, because the alternative will be liquidation, etc. So I appreciate in those cases that was a possibility. But I think in any matter where any case where there is competition, I don't think that would really matter as much, because at the end of the day, the competition will make sure that liquidation value disclosure becomes irrelevant to the bidding price. And really, I think that's the crux of the problem. Is it possible for the RP to create enough competition? Has he reached out adequately? Has he presented the assets adequately? Has he managed to give, in the circumstances, as much information as is possible to enable a sensible discovery? And that leads me on to the next point. Inevitably, in an IBC process, it's a stress situation, so you're going to have poor discovery process. I think that's a given. What tends to happen is a lot of competitors will often find that they already have enough information. The truth is, in today's day and age, competitors are keeping such a regular tab on each other's businesses that they tend to have a lot of the information even before the IBC starts, the information that matters to them. In terms of liabilities, tax issues, etc., there are more and more judgments now which make the whitewash of the liabilities fairly clear. So really, I think that's of limited risk for an incoming investor. So I think, coming back to my original point, really the crux is, can you generate enough competition? And how do you go about that? How do you improve competition? And if you got that wrong, then everything else is going to be a problem.
That's correct. In fact, I was saying that COC needs to come up with some more creative ideas. Do you think the Swiss challenge process, which is being used by many creditors these days, and in fact part of the regulation also, the Swiss challenge process is going to add extra benefits to the creditors, because now you can actually have challenges, more competition in the system?
On a lighter note, I don't know why adding the word Swiss, people think it's going to be damn good. Answer is no. I think what's going to change the system is an electronic bidding process, which the PPRP for MSMEs has suggested. Because a lot of people talked about what happened in DHFL, right? I mean, Pulkit, you and your firm were involved in that. So there was a lot of angst about the process and how the process could have been improved. And this has been going on, since the early days, since Binani, right, when Ultratech came in and souped the company up. The question is, are you going to give certainty to a bidder that if there is a set process and a set timeline, once he gives a price, no matter what the other person offers, his price will be accepted? And if the answer is no, you're going to have unfair bidding practices. If the answer is yes, people will understand the timeline and will bid in that process. And in fact, there are suggestions made by certain theorists on this process, that by having a fixed timeline, a fixed process, you can improve your bidding, because it leads to irrational bidding. When you only have 5 minutes, right? I mean, I know people who do eBay, etc. You only have 5 minutes left. I want to get this asset. But if you know that you can watch for the other's price, see where it lands, and then add 20% to that or 5% to that, and then bid more, you're not that worried when the time clock is ticking. So really, I think what's going to change the bidding process is if there is a fixed e-voting process, after which no one, no matter what price you bid, can win. And in that bidding process, if you have a Swiss auction because you like the prefix Swiss, go for it.
So certainly, Mr. Desai is not a big fan of the Swiss challenge process, but thank you so much for your views. I mean, Drupad Wagani, what is your view about this, and how
So
can
Swiss challenge or whatever process, at the end of the day, we are looking for maximization. Whatever comes your way in terms of your maximization of your asset, be it Swiss challenge, you call it intercept. Before Swiss challenge, people were calling it intercept bidding, or whatever it is. At the end of the day, you have to look at whether the creditors or whatever that is at least meeting the liquidation value, or always the endeavor is to get more than that. But as what Saurabh also said, that at the end of the day, you have to look at people bid for the plan or bid for the asset. What is there is the asset? If there is no asset, technically no one's going to come forward and bid. So, but one thing I definitely wanted to add, I was just hearing other panelists also, that we are talking about low recovery rate and all of that. One big issue that we have definitely faced at the adjudicating authority level, where though the BLRC and the court says the time is of an essence, speedy disposal and all of that, we've seen like ample number of, we also, maybe if we represent the corporate debtors, we feel we take undue advantage of section 60 subsection 5 file application, basically to just prove the question of law. And NCLT, I somehow will get really into the merits of it. At some point of time, NCLT has to feel that no, I have to draw a line, dispose of the application wherever as fast as possible, so that because we've seen in cases plans have been approved in 2018 but still not been implemented. And people at the end of the day, even you would have looked at Amtech Auto, people would have filed left, right, an application, or the resolution applicant wanted to withdraw, but NCLAT said nothing doing, force major, COVID coming in, the value, whatever that I would have bid for, the value would have come down. So at the end of the day, if we have speedy disposal of applications and rightful time and implementation, because in one of our other accounts also we've seen the resolution applicant submitted a plan and within 6 months, where he knew that within 6 months he's going to make a profit with the plan could not be implemented, he filed an application for withdrawal. So if we have timely disposal, I'm sure we can see the recovery rate or the percentage going up somewhere here and there. And I fully agree to what Pulkit said. I think even I get somewhat disappointed that we see the percentage go here, so that people are comparing good, bad, whatever it is. At the end of the day, it's a commercial wisdom, and it's another statute where it's kind of, maybe I would not say recovery, but it's more of a resolution process in place.
No, that's correct. In fact, as far as this whole issue of validity period is concerned, I think it's pretty much settled now with the Radicom solution and EBIC's case, that there's no concept of validity period which a applicant put in and said that I'm not going to implement the plan after the expiry of that period. So that basically draws me to my next question: that what are the few landmark steps or amendments that have been included in the IBC, because of which you think that the entire process has been the speedy recovery or the speedy resolution of the asset is happening. Mr. Saurabh Pandey, if you can just I can have your views on that.
See, I think there is a conundrum in the question, that I think somewhere all of the panelists are unanimous in the view that the resolution needs to be speedier. So certainly there is scope for a lot more. I think I'm sure it is in the works to have further push at the adjudicating authority level to give resolution decisions faster. I think host of Supreme Court judgments now have made the position quite clear also on that. And one welcome amendment that came in, I think that was post SR in CLAD judgment, where I think the position has been made very, very clear under 30 that really the issue of distribution is left completely to the committee. And the entire jurisprudence that has evolved thereafter has made the position very, very clear that the decision on the resolution plan, insofar as all aspects of commercial wisdom are concerned, are left to the COC. I think the amendments that have been brought about in 30 and 31 are very, very critical. Even the amendments which came in 31, making the position clear about the government and the fact that the resolution is equally binding on the government authorities. That's also very, very critical. Of course, further steps probably will help if it percolates down to the ground level in the tax and other departments, because even now we do see that there are a host of litigations that a successful resolution applicant quite often faces post resolution, despite the position being fairly clear under the law that come in from various departments, whether it's mines, tax, etc., etc. Certainly, the timelines which are given, and I think if further timelines come in under the code, that will be very helpful. One just hopes that the judiciary doesn't come out with a directory finding for the timelines, which in the past has plagued the process timelines. 29A, of course, at the initial stages of the process was also a very critical amendment. And that's really in line with the objects of the code. And some of these recent amendments which have been brought about with the pre-packs, etc., they are a very good, I would say it's a good experiment to see how it pans out. Because if it, in cases like MSMEs, etc., given the track record of resolution, it is a fit case where an experiment really has been drawn out, where we are really looking at a debtor in possession sort of a ambit. So these are some of the important amendments. Of course, it's a relatively new statute, and credit goes to the government and IBBI that they have been very conscious and have been very proactive in making changes, given the dynamics of the working of the code.
Thank you so much. 5-10 minutes ago, Mr. Desai, you were talking about this clean slate principle or the fresh slate principle, which is going to help the resolution applicant. If you can just talk a bit about this principle for the benefit of our attendees, what exactly is this whole principle is?
Sure, I think Saurabh touched on it very comprehensively, but the short point there is that you're coming in as an investor into a company which you're buying in an IBC process. It's a stress process. The promoters are unlikely to be cooperating. In a usual M&A process, you will have a willing seller.
Correct.
And a willing seller means that you can get information, you can get access, you will see the assets of the company in a better light. You will be answered questions, of things which have happened in the past. You'll be given all the relevant information. But when there's an unwilling seller, in a sense, because there's no promoter around, you have to make the best of it because the resolution professional, has been thrown into a company. He has a few months to, make it a little shiny and attractive and give you as much information as he can get. And that's never going to be the same as a regular M&A process. Which means that as an incoming investor, you're worried, right? What am I missing out on? What information do I not have? What risks can pop up after I buy it? And therefore, I may pay 20 for it, but then spend another 40 for the next 5 years trying to resolve the issue. So that's a huge specter of concern for an incoming investor. And I think if you can break them up into broadly 2 categories, right? Civil and criminal. Then I think what the IBC has done in a combination of Section 31, Section 32A, and case law, as Saurabh mentioned, is that it has given a lot of comfort to an incoming investor that civil claims, i.e. claims from any stakeholder, whether it be government or a third party, can be effectively crammed down in an IBC process. And I think there was, despite the section, lack of clarity because of a few judgments around which talked about how if you don't, if the claim hasn't been submitted, then maybe it can be proceeded against subsequently, etc., etc. But I think there is now general clarity on the point that civil claims and all stakeholders are bound. So that's one. 2, obviously, I think, as GSW found out, ED and PMLA issues can still crop up because your assets can get, arrested or seized for ongoing criminal claims. I think 32A has given a lot of comfort again to investors that even criminal actions against the assets of the company, and the company itself, obviously, will not continue post, subject to a few conditions. So both of these mean the investor is fairly comfortable that although he may not have been able to diligence the company in full detail, many of the risks he would have been concerned about in a regular M&A transaction, which he would try and fix with diligence, representations, maybe insurance, etc. He doesn't need to worry about because it's been fixed by the law.
Thank you so much, Mr. Desai and Mr. Saurabh Panda. You briefly touched upon Section 32A, 29A, and obviously the fresh slate principle that was really helpful for the attendees. Now I'll move on to the next subtopic of the day, which is cross-border insolvency. And I'll be happy to have views of Mr. Ritesh Kavadia on as to if you can just explain as to what cross-border insolvency is, and how will it impact the resolution of stressed asset if they're having multiple assets in multiple jurisdiction or countries.
Yeah. So insolvency deals with the how we do the business, how companies do the business, and we're into the era where many multinational companies, transnational companies are operating, and they have assets and liabilities in more than one territory. And once we face insolvency situation of such company, then this question comes how we deal with the assets and liabilities that lie in some other jurisdiction. Fortunately, this ancestral model is a solution where, and it has been adopted by quite large number of states. Some 53 nations have already adopted this cross-border law for this ancestral. And we are India is also contemplating that we can also adapt this model law so that all the stakeholders on ex ante basis know what is going to happen in the cross-border situation. Because even if we don't rule out or lay out a framework, these cross-border situations will come and will hit us. Like in Jet Airways, we faced a situation, and in many other companies also we face a similar situation. Fortunately, in Jet, this NCLT in its inherent powers, NCLT and NCLAT in inherent powers dealt with the issue, but ultimately it is going to be a burden on the executing authorities if they have to deal with these situations without any proper legal, you can say, guided path. And unless we have a proper legislative framework, this whatever NCLT does in its inherent powers, it will be challenged many times over. There will be many litigations. So, in the interest of resolution, in the interest of comprehensive resolution, we have to have this cross-border framework to deal with this insolvency situation. In this cross-border, there is a concept of center of main interest where company has its prime business, and the proceeding in that jurisdiction is termed as main proceedings, and all other proceedings assume the position of non-main proceedings, and all these proceedings happen in coordination. There is a protocol for coordination among professionals, among the adjudicating authorities, courts, and ultimately a comprehensive resolution is reached out, and it is in the benefit of all and for all the stakeholders.
Thank you so much, Mr. Kavadi. In fact, you touched upon the coordination between different players and stakeholders. So, according to you, what is going to be the system by which these different stakeholders, like foreign IPs, courts, and corporate data, they'll be connected, or they'll work in a tandem? How this is going to be in place?
Basically, there have to be some protocols between different adjudicating authorities to deal with the issue, and it has to be case-to-case basis. But this framework provides a guided path to arrive at such protocols. Even in the absence of such framework, we had a protocol with the Netherlands authorities for reaching Netherlands professional for reaching out a resolution, but as such, we are much better way to position to reach such a protocol if we have a framework guiding us.
Harshit,
Yes.
if I'm coming,
Yes, sir.
just to add, of course, I think going forward, a more detailed sort of prescription will have to be set out in terms of how the overall cooperation will work out, considering it's obviously one of the most critical aspects in a cross-border insolvency framework, because really you are looking at foreign insolvency professionals interacting with our courts and vice versa, where our insolvency professionals would be interacting with courts there, and the courts also will need to have a line of communication for an effective insolvency resolution spreading across jurisdictions. So that of course becomes critical. What I understand is that Singapore has really adopted the JIN guidelines quite effectively. Now, there is a recommendation, of course, for India also to sort of take that path of the JIN guidelines and adopt it as and when the cross-border insolvency framework does come out. If indeed that comes out, it will be something completely unseen till date, where we will have a platform really for interaction amongst courts, and that it will be interesting to see, and very interesting times, I believe, not just for lawyers but also for insolvency professionals to be able to take up these kind of cross-border insolvency matters cutting across jurisdictions, and that will be very interesting to see how the facilitation really happens. And how that platform really works out of interaction between different jurisdictional courts. So I think the guideline approach eventually will be a more sort of sustainable model given the fact that, so far the experience in a protocol-based approach or an agreement-based approach is not great, because, you may have it in one-odd cases, but if you have to have it on a sustainable basis, you really need to have a sort of a guideline-based model.
In fact, you also got me thinking that, do you think when we're talking about cross-border insolvency, do we actually need a universal body somewhere so that, this cooperation between different countries and their bodies would become easier? And that was somewhere possible?
See, so far we are really looking at, the model law, correct? As the model law on cross-border insolvency is our sort of source per se, which we are really looking to adopt with some flexibilities around. Practically, to have different countries really submitting themselves fully to a global body does not appear a very tenable proposition. But of course, if you have a common sort of consensus on the basic rules of the game, which is really what the model law provides for, I think that appears to be a much more tenable proposition at this point in time. I mean, happy to hear if other panelists have a different view, but my personal view is that, to have a global body regulating each country on this may not probably practically work out.
Happy to have views from other panelists. If Mr. Desai has a view, Mr. Kavadia, please.
No, I think I agree with Saurav. I don't know whether you're going to, have an overriding body over here. I do think, as other panelist members said, this is a case of providing useful guidelines to allow the practice to develop on a case-by-case basis. So, someone touched upon Jet Airways. That's a matter which my firm worked on, and I worked on personally. I think what happened over there is because the NCLAT stepped in and said, listen, there is a process in India, there's a process in the Netherlands. Obviously, there are important assets in the Netherlands. It makes sense for people to talk together and resolve together. And I think also, not only that order, but also very importantly, the mindset of the resolution profession in India and in the Netherlands was towards cooperation, right? They wanted to work together, they worked together, and I think that made the process a real success, because it could have gone very badly for both. But that may not always happen, right? You may not always get a useful order, you may not always get meeting minds amongst the resolution professionals of different countries. And that approach that whatever the hurdles, let's work together. That always happen. So I do think it's important to have guidelines in place and then let people work together to achieve a common resolution. And honestly, I think it's critical because there are many companies where assets of the Indian corporate debtor will be sitting overseas, and not have a guideline in place is only problematic for the Indian creditors. Will there be, things of concerns for Indian creditors? I think there will be. I think Indian creditors need to be very careful in terms of where COMI is settled. It will be a rude shock to an Indian creditor where it's, lending to an Indian company and suddenly finds that COMI of that company is elsewhere. And, that's going to upset his thinking about how insolvency resolution is going to come about. So that's something Indian creditors will have to keep a careful watch on. But otherwise, I think this is only going to be beneficial for Indian creditors in paving the process to make it smoother when assets are overseas.
Understood. I think you touched upon 2 points, one being where the COMI is, which is center of main interest, and the other being Jet Airways case. So I would like to have views of Drupal Bhagani as to, if you can just tell our attendees, what is the center of main interest and how this impact the entire proposed process under the ancestral model.
So in order to reduce the conflict between the jurisdiction, the model law of the cross-border insolvency brought forth the concept of center of main interest, which is COMI. So when a domestic court considers a foreign country as the COMI regarding a debtor's insolvency process, and the domestic court shall recognize the insolvency process. So the insolvency proceeding in the COMI would be considered as the main proceeding. So let's look at, so there's a recognition as the main proceeding will result in automatic relief such as enforcing and moratorium domestic proceedings. So basically, this is more of a center of main interest where it will consider the main proceeding of that. Is what is COMI.
Thank you so much, Mr. Bagani. And in fact, I think one of the question which I have here is that assuming there are two different jurisdictions and the intent of insolvency laws is different in both the jurisdictions. For example, Indian insolvency law is more towards recovering the corporate data. And what if the other jurisdiction is going towards liquidation? How do we, come up to a win-win situation? If I can have views from Mr. Saurabh Panda here.
See, you will really need to concede in to the main proceeding, right? I mean, that's how the real that's how you really harmoniously align the different processes in a process which is based on the model law. That you'll the non-main proceedings are in a way subservient to the main proceeding, right? Because it's the main proceeding which will really take take precedence. And depending on each case and which is the main proceeding, I think that is how you'll really need to align the processes, because of course, as you rightly said, each country will have its different processes, different objectives of insolvency resolution. 5 years back, for example, we did not even have this whole construct of an IBC sort of a framework, right? So that you really can't control in between different countries and jurisdictions. But what you certainly can control is alignment of the rules governing this, right? And once you have that sort of clarity that it's really the main proceeding which will prevail, that I think should sort that issue out. Having said that, in the recent past, there have been one or two cases where even the working of cross-border insolvency in certain developed jurisdictions has faced certain tough questions. I think there was one case, I forget the name, in UK where there was a challenge that whether recognition also includes enforcement or not, right? I think in that particular case, the UK court held that it does not include enforcement. But that really, practically, if you think about it, defeats the whole purpose. That sort of an interpretation. So I think it may be important, when we put forth our statute or statutory amendments and the rules, it's made adequately clear that recognition is toothless without the ability to enforce based on the main proceeding, right? And so therefore, I think once that is sorted out, there should not be much of a difficulty in aligning the two main proceeding and the non-main proceeding.
Okay, I think we have already exceeded the intended time for this panel discussion, but we still have two topics left. So with the liberty, I'll probably briefly touch upon the ADR bit and the PPIRP, because PPIRP is again one of the very new concepts under the IBC. So if I can have views from Mr. Pulkit Gupta, what do you think this alternative dispute resolution, will that work in an IBC sort of regime, especially given the kind of country we live in India? Do you think it's possible?
So obviously a lawyer would be able to answer it better, but my experience of it while I worked in UK is that conceptually it should definitely help. Obviously, considering that everybody is aligned and everybody is aligned for almost last 2-3 years, that the biggest challenge in timeline is the timing with the adjudicating authority, and these concepts help in sort of creating some bandwidth for them. So conceptually it should help, but my personal view is that in an insolvency scenario, normally the dispute is not just between two parties. If company is bankrupt or insolvent, there are multiple stakeholders who are impacted. So you, in a bilateral, even if you have a solution with an operational creditor, that does not necessarily resolve a problem. If you have even a solution between a bank and a company, that still might not necessarily resolve the problem unless you do a slightly more holistic restructuring. So it should definitely help, but it would have limited implication in cases where the problem is slightly more deeper and which might need a restructuring through an insolvency process. That's my
correct.
limited view on this topic.
Thank you so much, Gupta. If I go to Mr. Desai, what is your view with respect to EDR mechanism vis-a-vis the IBC process in India?
I know it's a difficult one because conceptually it makes a lot of sense. I'm sure there are situations where it's possible to reach a common understanding rather than putting the company through insolvency. And that must be the case because we're seeing a growing number of cases where post-admission, suddenly the creditors come to court and say, oh no, now we're working on a resolution and, delay the formation of the COC. I don't understand that. I mean, what's going on? Can't you make up your mind beforehand? What are you trying to do? Trying to just add leverage? Have you made this a recovery process? Because really what's happening is because you're in IBC, but it's paused, other creditors have lost their leverage and they can't put, the company into IBC. We have to fight against, the existing process and say, hey guys, if you're not reaching a resolution, let us start the process. But effectively, you just, you block the process. So is it sensible? Yes. I'm just worried it's going to be used as one more mechanism to delay the process, right? But I mean, I see no harm in trying it out, and if it doesn't work, to remove it. Unfortunately, trial and error is not how laws work. So I'm skeptical. I appreciate the concept, but I'm skeptical.
If any other panelist has any view respect to the ADR mechanism, please do let me know, or we can move on to the next segment, which is the PPIRP.
Harshit, basically this ADR mechanism works best when this promoter is keen to settle its dispute with the creditors, and it can work only if there are one or two creditors.
Limited
There are
creditors.
large number of creditors, companies are severely under distress, it is not going to work. But if the distress is temporary and this promoter wants to settle, then obviously it makes sense to some what extent. And even if we see that some 20,000 applications have been withdrawn even before admission, they are the cases where some negotiation, some discussion, some understanding has been reached, and it could be a court monitored or an adjudicating authority monitored, you can say, negotiation as well. So ADR can be useful in that sense. And even after admission, just like Nilang told, we have seen around 1,200 withdrawals through NCLAT or NCLT or under Section 12A. So these are the potential where the credit, even after initiation, the creditors wants to settle their. But ultimately, there is no, it will be unfair to have some cramp down on stakeholders. And if it's not cramped down, all the stakeholders have to be on board. So to a limited extent, this ADR mechanism can be useful. Even this pre-pack has some aspect of ADR in itself, because the creditors and debtor, they arrive at an understanding, and especially at the MSME level, the number of creditors are not more. So some element of ADR is very much there. Resolution professional as such is discharging some sort of duties there, and this the difference is that they are going to adjudicating other to get the blessing, and when it's get the blessing, it's mandatory or binding on other stakeholders also. So we already have some aspects, but formally it is not there, and we have to evaluate whether it can add to, if we mandate it, can it lead to somewhat delays in the process? That aspect has to be very, very carefully thought of.
Understood. So I'll just move to the next segment, which is pre-packaged insolvency resolution process, which is currently applicable only for MSMEs. Mr. Pulkit Gupta, would you like to brief us a bit about this process?
Yeah, why not? So I'll try and sort of keep it brief. So basically the idea is that you have some sort of an agreement between the lenders and the company before you go into CIRP process, and then still to take the benefit of everything you get when you get a company through a CIRP process in terms of approval from NCLT and write-off of opening liabilities. All of that is also given to you. So you agree a plan in advance and then go to the formal process. So there are two stages, informal and formal. And key thing is to get the benefit of an insolvency process so that it's binding on everyone. And at the same time, the important objective is to try and do it quickly. Timing, obviously, this is a 90 plus 30-day process as compared to 270 plus 60. So that's the most important objective, which is to get this done in a quick manner. And as the name suggests, it is pre-packaged. So the plan largely should already be agreed. Just one last thing on this, which I've seen in UK, is that normally in UK, a pre-packed plan would be filed to a court on a Monday morning and it will be approved by Tuesday evening. So that's the timeline they work on. Obviously, we still have a long way to go, but that's effectively what a pre-package work in a slightly more matured market.
Thank you so much, Mr. Bulkar Gupta. Any other views of any of the panelists with respect to the pre-packaged insolvency resolution process?
I do, if I may. I'm a big fan of the pre-pack process. I think it'll take some time before we reach the level of maturity Pulkit mentioned in some other jurisdictions. But I think the pre-pack fills a void which we are seeing today in our system, right? Think of yourself as a promoter. You can see your company going into default. You want to resolve it. You have 25 lenders. You start talking to the key lenders. And some say yes, some say no. You agree a broad mechanism with them. But it's going to be, what about those lenders who say no? How are you going to cram down the dissenting guys, especially if you have foreign lenders, if you have mutual funds, pension funds, NCD holders, etc., who are not bound by RBI regimes? So can you do a partial settlement with some banks and let the other guys continue? That's never going to work, right? So you try desperately with your lenders to reach a resolution. You're willing to offer 60, 70, 80 cents, but the banks find it difficult. The others said no. Now the default has happened. You keep trying, you keep trying, you keep trying. There are threats of insolvency. You push back because you don't want insolvency to happen, because you're still trying to achieve a resolution. Now 1 year has passed. You become 29A barred. Now you definitely don't want the company to go into IBC. You push, push, push. You try and cajole the lenders. So you fear distress on month 1. You're probably in month 35, right? By pushing, pushing, pushing before the lenders give up and say, now we're going to put this company into IBC. What's happened in these 3 years, you think? You think the value has gone up or the value has gone down? I mean, obviously value has gone down, right? And then everyone's saying, oh, IBC is horrible, really depressed values. This is pathetic. But why is no one talking about when this company came into IBC, right? I mean, a posh resale value is great, but not a 35-year-old Porsche without wheels and with the engine rusted, right? So if you sold it when it was in prime condition, sure, you should have got great value, but you brought it in a rubbish state. So really, how do you incentivize promoters to take it into IBC is the question. And you're not going to incentivize them with 29A. You're not going to incentivize them with saying the RP is going to come in and kick you out. You're not going to incentivize them by saying your company can be bought by someone else. You're not going to incentivize them by saying the company could be dragged in the process for 1, 2, 3 years and you'll be, embarrassed in your community, etc. That's not how you entice a promoter. The way you entice a promoter is to say, when it's in distress, hurry. Before you're 29A barred, strike a deal with your large creditors. Get the benefits of the IBC whitewash. Get the benefit of striking your deal with your bankers. Get the benefit of running your own company with RP supervision, not replacement of the board. And that's what PPRP is in India today, right? It allows a promoter to strike a deal with his large lenders, 66, 75% of his lenders, outside the IBC. Maybe sign an MRA. Bring it into IBC. Not have the RP override him, but the RP has to supervise him. And as long as he's paying off the OCs, he can go into the IBC and out of the IBC potentially during the same group. So no embarrassment in community, right? It's more like the Chapter 11 protection, really. And this is the mechanism where you tell lenders, it's your bridge between the RBI circulars, which was allowing a partial restructuring, and the IBC, which allowed a full restructuring, but was kicking you out, was inconveniencing you, was stretching it out. Here's a midway path for you promoters. And the idea is, if promoters pick up on this, I think we're going to have a swathe of promoters who, when they sense distress, they're going to reach out to try and restructure rather than push back until it gets too late. And then everyone loses, including the promoters. So I think it's critical. I think, this is an important development. If it works well, it's going to be a game changer for India.
Yeah, and I would also add, I've done a lot of work in pre-pack in last 3 years and behind the scenes also. And I personally feel that like last 5 years was the success of CIRP. Next 3 to 5 years would be how good PIRP would develop. If it happens the way it should, then it will be a real game changer. And in a way, I was happy that PIRP for the discussion today was the last topic, because had this been the first topic, we probably ended up only discussing that. But maybe some other time.
I think I'll have one or two more questions before we conclude this discussion. So one major issue is ultimately we have different kind of regimes in IBC. We have corporate insolvency resolution process. We have insolvency of personal guarantors. We now going to have cross-border insolvency. We will be having PPIRP, and ultimately the authority being NCLT. Do you think, and considering the current situation we are into, where there are so many pending cases, how the adjudicating authority is going to deal with all these different kind of cases? And what do we do? I mean, ultimately, do we need more benches?
More members for sure.
I think.
So I personally feel for the personal guarantors, there should be another member only looking at the guarantee. And as what Saurav also suggested, there has to be some kind of coordination, some kind of discussions, and between the members who are handling the matters, because that is very important. At least there has to be common orders. You can't be different orders passing by different members.
Yeah, I think the other thing is, effectively we'll have to eventually go back to NCLT for certain things, and that's a given. And of course, there is a limitation to the number of benches and the number of members that you could potentially have. Of course, to start with, the expectation would be that we fill the vacancies that are there. I think some steps were taken last year towards that. But more importantly, probably it would help if the timelines which are there already in the statute and whatever is proposed, if those are really adhered to in letter and spirit, certainly the pendency will not be as high as it currently stands. And this will only multiply if we don't have the sanctity of the timelines maintained, not just by the process stakeholders, with the RP and COC, who are also equally responsible. They also have a role to play in ensuring that the process concludes within time. We've all now seen during the pandemic that even the bankers are able to efficiently run the processes working from on a virtual platform. All judicial forums now also effectively work through the virtual platform. And certainly that does indicate that we have the potential and the ability to conclude processes faster and making use of technology. And given the clear jurisprudence that has evolved, that the role of adjudicating authority is relatively limited. If indeed the adjudicating authority and the members rather take cognizance of that and give precedence to the criticality of time, which is one of the key objects. I think effectively the value and all other aspects are really driven in some or contingent on the amount of time that is taken in the process. If we take too long, like somebody took the example of Antec, and there are several such examples where we've unfortunately taken way beyond the timeline that is otherwise provided under the code. I think if time is sorted out in terms of the timeline which is given under the code being sort of adhered to in large number of cases, we should be able to manage with the rest of the infrastructure sort of coming up.
Understood. Thank you so much. I mean, if any other panelist has any other view on this query or any other query in general, we can take that, or we can probably move on to Q&A and then towards the conclusion of this discussion. Should we then move to the Q&A?
Yeah.
Riddhima, if you can help me with this Q&A and the kind of questions which we have had.
The Q&A handle must have forwarded a few questions to you that we've received from the attendees over the chat feature. Or we can have have a member of the editorial board read out the questions for you, and then maybe you can take over from there.
Yes, please read out the questions so that the panelists can probably respond to that.
Right. Dhaval, could you please read out the questions?
Yeah, sure. Am I audible to everyone?
Yes, Dhaval.
Yes, sir. So the first question which we have received is, what can be the interplay of Benami law for individual insolvency law?
Understood. Who would like to take that question? Mr. Desai, would you like to respond to that?
I followed the impact of Benami law on insolvency law.
Dhaval, could you repeat the question, please?
Sure, sir. So the question says, what can be the interplay of Benami law with the individual insolvency law?
Right. I haven't considered this in detail, but my off-the-cuff response would be, to the extent there are proceedings, and let's assume for a minute we're talking about individuals, and individuals have, hidden their assets through, Benami holdings, then I think this sort of links into what Pulkit was saying earlier. To the extent once you have orders against a personal guarantor, being an individual, and you're trying to make recoveries from them, as a resolution professional in a personal guarantor's insolvency process, do you deal with only the assets you can see or are disclosed to you, or are you able to take further actions basis Benami laws and bring more assets into the estate of the personal guarantor being dealt with? And I think if there is an ability for that interplay to happen, then I think there will be more pressure on personal guarantors, as we've discussed earlier, but also more effective personal guarantee resolution. And thirdly, maybe an incentive for the banks and the financial institutions to actually run a PG process, right? Knowing that the combination of these laws will actually, suck out the assets which have been hidden by the personal guarantors and make it worthwhile for them to proceed against personal guarantors. Sorry, I'm not sure that answered your question. It wasn't a very technical answer, but I do think it will be a useful process.
I think that actually answers the query. In fact, it's directly related to what Pulkit was also mentioning earlier with respect to the asset tracing. That what happens to the assets which are currently not available as on the day of the initiation of the insolvency of the personal guarantor. Any other questions? Do we have any other questions?
Yes, sir. So the other question is, what are some ways by which the Insolvency and Bankruptcy Code can manage and regulate the issue of COMI migration, which is adopted by certain corporate debtors under cross-border insolvency?
The COMI migration, the center of main interest migration.
Yes,
Mr. Kavadia, would you like to respond to that?
Yeah, basically this main concept of COMI arises just because there can be some arbitrage, or someone might try to take some arbitrage out of it. By default, a registered address is good enough for determining where the insolvency proceedings should commence and do. But there is some incentive with the other. There is an opportunity with the creditor debtor that they can simply shift their registered address and avoid a certain jurisdiction. So there, this rebuttal of this registered address comes, that look, your main interest is there, you do your business at this place, your registered address does not justify your center of main interest being there. So in that aspect, this COMI concept comes. Of course, if the other jurisdiction has some different views, there will be a discussion, and somehow a solution has to be found. I'm not saying that there cannot be any dispute, but potentially a debtor should not be able to exploit this legal provision, and that's why this COMI has been kept as a rebuttable concept.
Thank you, Mr. Kavadia. Can we have next question, please?
Yes, sir. The next question is, what is the current position of law on whether the avoidance application can go beyond the CIRP process in light of the Venus judgment of the Delhi High Court?
I think I should take this. Basically, this it was intention that this proceeding should continue beyond this resolution period. If it goes to liquidation, the liquidator should continue. Otherwise, also this proceeding should continue. And it was not thought that this proceeding has to culminate before this resolution process. Union of India has preferred an appeal against this Venus order judgment, but this matter is sub judice right now. But the legal legislative intent was this proceeding should start beforehand, but as such, not required to culminate before resolution.
Thank you so much, Mr. Kavadia. In fact, if I can just add one more small bit to it. So don't you think so generally before passing or approving a resolution plan, or rather rejecting or approving a resolution plan, these applications or any of the miscellaneous applications should technically be adjudged by the NCLT or the adjudicating authority? Therefore, this question would not arise of not having a jurisdiction.
No, but basically, ideally this should do. But if the result of this solution, this formulation is that this resolution will be delayed altogether, then it's you can say it will be counterproductive. This resolution plan can very well provide how these proceeds that comes out of this avoidance application will be dealt with. They can be assigned to any other party. They can. There are a number of permutation and combination that can happen. But holding a resolution just for so that avoidance application, because that itself is a complex judicial process to get this assets back, and once this decision of A will be there, it is not. You can say. Surprise if it will be challenged before the NCLAT and even higher. So getting a finality on it, you can only say that it will be counterproductive. The resolution should happen and resolution should go on, but resolution plan should clearly state how this proceeds that come out of these proceedings will be dealt with.
Understood. Thank you so much, Mr. Kavadia. Can we have the next question, please?
Yes, sir. The next question is, who is responsible for making payments for the resolution process and fees of resolution professional in the case of personal insolvency?
Mr. Saurabh Panda, would you like to answer that?
No, that will in any case be taken care of as a part of the repayment plan itself. The whole scheme of the code is that the process costs obviously always take precedence in, whether it is under the CIR process or under the personal guarantors insolvency. The process costs always take precedence, and essentially either under a or a resolution plan, they will have to be settled in priority.
Thank you so much. Do we have more questions?
No, sir, we don't have any more questions.
Thank you so much. So I think this probably here we can conclude today's panel discussion, and thank you so much to all the panelists, and thank you RGNUL and IBBI for having all of us here. Over to you, Riddhima.
Thank you.
Thank you.
Thank you so much, sir. We sincerely appreciate the efforts of all the participants, and we wish them all the best for the future endeavors. And we also would like to thank all the esteemed panelists for taking out the time today. Harshit sir for moderating the event, Mr. Sudhakar Shukla sir for giving the address, and we thank all the attendees as well for attending the event. We also wish to thank IBBI for this fruitful collaboration, and we wish everyone good health in these times. And thank you everyone once again for gracing us with your presence today. It was really an extremely productive experience for all of us, and we have a lot to learn from your expertise. Thank you so much, everyone.
Thank you so much.
Thank you. Thanks all.
Thank you again.
Take care.
Thank you, sir. Thanks.